to turn your camera off. Now's the moment. So the vision of Coburn Place is to illuminate a path forward to restore hope and promote healing for survivors, adults, and kids. And at Coburn Place, we offer that through housing choices and support services that is made possible through community partners, donors, volunteers, and staff. That compassionate support, we know, is a essential thing that helps families create a fresh start. And we're really eager and thrilled to be able to spend some time with so many of those people who are in this room with us today. I am very excited to introduce today's speaker. She is an expert in the field of harm reduction and domestic violence. She's worked in direct victim services as both an outreach and court advocate, and has served as the director of transitional housing before joining the staff of the Indiana Coalition Against Domestic Violence, which, if you're not familiar with ICADV, we really encourage you to check out their website. They do incredible work, and we are extremely lucky to be a member of that coalition. Before taking her current role at the coalition, she served as ICADV's training coordinator for 15 years. And she is a survivor of a violent adolescent relationship, and truly has spent her life working to provide education about the effects of domestic violence on individuals and on the community. So with all of that said, it's my pleasure to turn this over to Caryn Burton, the Homicide Reduction Strategies Coordinator at the Indiana Coalition Against Domestic Violence. Caryn, we're really glad you're here today.
Thank you, Julie, so much for welcoming me, for inviting me to come and have this conversation. As Julie said, my name is Caryn Burton. I am the Homicide Reduction Strategies Coordinator at the Coalition, the Indiana Coalition Against Domestic Violence. I have been in this position for a little more than about a year and a half. And I give this background because this is a specific position that we created in part because of what we saw as skyrocketing homicide numbers, particularly during the pandemic, particularly during the time afterwards, where we did not see a significant fall in those homicide or those fatality numbers. And so we recognized that the issue of intimate partner violence homicide, while it is an outlier, it is the rare outcome. It is something that we know is preventable and therefore is predictable and therefore is preventable. And so we wanted to take a look at and spend some time specifically examining what are the ways that we can prevent that worst case outlier outcome. We know that's predictable and therefore preventable. And so how do we make sure that that doesn't happen? And firearms, addressing firearms and the intersection between firearms and domestic violence is one of the key ways. I want to give a little bit of a content warning this morning before we get started. We're going to be discussing very sensitive and potentially triggering content, specifically talking about both firearm violence and fatal incidents of intimate partner violence. We acknowledge that domestic violence fatality is rare. It's, again, as I said, it's the outlier. It doesn't adequately reflect the lived experience of survivors of intimate partner violence, which are the vast majority of individuals that we see and talk to and work with every single day. But we also want to make sure that we acknowledge that this rare occurrence, this outlier and most tragic outcome happens, and how do we address it and how do we look at it? But please take care of yourself during this conversation and do that in any way that feels best to you. So the conversation around firearms and domestic violence, the intersection thereof, starts with the fact that we live in a state that fails epically at protecting us from firearm violence in general. That just is a truth that we live every single day. But we live in a state that fails at protecting its general population from firearm violence or from the presence of firearms. But we also live in a time where the presence of a gun where there's intimate partner violence increases the likelihood of a homicide between 6 and 10 times, depending on the research that you read, depending upon the study and the variables and how they present it. It's massive regardless, but anywhere between 6 and 10 times more likely to lead to a fatality. Last year, during the fiscal year 22-23, so looking at July 1 of 2022 to June 30 of 2023, just this last June, we had 78 intimate partner violence related fatalities. Of those 78, 66 were committed with a firearm. That's 84%. Now, what that means when we look at our state data versus our national data, national average of violent deaths committed with a firearm, even domestic violence deaths, is between 50 and 55%. That puts us easily 30% above average in terms of our firearm deaths, but specifically our firearm deaths that are related to intimate partner violence. We also know that we have a very, very high level usage of strangulation as a tool of violence in intimate partner violence. So where there is a non-fatal strangulation attack, where that history exists within the relationship, the level of fatality there just jumps massively. It's a 750% increase that you could be eventually killed by your partner. However, most of those deaths actually happen with firearms. The strangulation is the precursor, it's the warning shot. The firearm fatality is what ultimately ends up being the cause of death. And so looking at the extreme level, the extreme number of non-fatal strangulation attacks that we have prior to a firearm is just terrifying. So we really have to look at what is happening in the state of Indiana to understand why this continues to be such a high level issue. And as I said, the state of Indiana gets an F in terms of our level of protection from those in charge, those in authority in our state. And that's based on ratings that are provided by the Gabby Giffords Law Center, which really is a leading researcher and organization, that guidance organization to look at firearm violence. So as I said, Indiana earns an F. I want to talk a little bit about the laws in the state of Indiana. What do the laws tell us? What do they say? But I have to preference, sorry, my words today. I have to preface this conversation by saying, I am not an attorney, not a lawyer, don't play one on TV. I don't have a JD after my name, but what I can do is talk about, what does the law say? What does the Indiana code tell us? And that's what I'm going to do. So in general, what we know, Indiana law provides very little regulation, very little public protection from access to or presence of firearms in our lives in general. We do not require a permit or a background check to carry a firearm in public, whether you are open carrying or concealed carrying. We do not require the retention of sales or background check records regarding firearm purchase, nor do we have a reporting agency within the state. There is not a central repository for that information. We don't even require people to keep them. Go ahead and run it, and then whatever you want to do with it, you do with it. And if we need that record, I guess we're out of luck. We allow gun show purchases. We shield manufacturers and sellers from lawsuits resulting from any kind of liability that they may have because of the actions of somebody using one of their firearms or because of lack of safety that's associated. I live in a town, and I literally live 3/4 of a mile from our county fairgrounds. We have a gun show pretty much monthly over at our fairgrounds. So I walk my dogs 3 or 4 days a month. I am walking directly past a gun show that is just out in the open, because it's not even in a building, it's out in one of the pavilions. And we allow those types of gun shows. We have no restrictions on bulk purchases, ghost guns, or assault weapons in the state of Indiana. And we do not assist licensed gun sellers. We do require that gun sellers have a license, but we don't assist them in running their FBI background checks or doing anything like that. So they're kind of on their own. It's the Wild West, to use the vernacular.
Caryn,
go ahead.
Will you explain what a ghost gun is?
Yes. So a ghost gun, that's a really good question. Thank you for interrupting. So a ghost gun ostensibly is a gun that is in some way manufactured or assembled in a way that cannot be traced. And what that means is when firearm parts are manufactured, they have a serial number that allows them to be traced back to the manufacturer, that allows them to be associated. So if it's been used in a crime, that serial number is associated with that crime. Ghost guns are they're created, or they're put together in a couple of different ways. One way you can create a ghost gun is actually to use a 3D printer, but you can also assemble a gun from multiple different parts, which makes it untraceable. Each of those different parts may have the serial number filed off. They may have conflicting serial numbers because the parts are interchangeable, and it becomes ostensibly untraceable. So it's referred to as a ghost gun. Were there any other questions, Julie, before I move on?
No, thank you.
Awesome. Okay. There are a few things that Indiana does do in terms of protecting citizenry from firearm violence, and particularly looking at domestic violence as an area of protection. So our law does have some general restrictions around prohibiting individuals who are convicted of a serious violent felony from possessing or carrying a firearm. Now, serious violent felony, there is actually an Indiana code that defines what all of those crimes, once you are convicted of any of the crimes that are on that list, you are considered a serious violent felon, and you are therefore by state law prohibited from carrying or accessing a firearm. Domestic violence is listed as a serious violent felony if it is a felony level conviction. For most of our advocates, any of our attorneys on the call today, many of you may know, usually, unless there are accompanying charges or unless it is a second or third offense, something that is exacerbating what's happening, the first offense for domestic violence, if you are convicted of a misdemeanor. So you wouldn't fall on this on the serious violent felony list. But we'll talk about another law that does kind of cover that gap here in just a second. We generally require that respondents in a protective order case may be prohibited from possessing or carrying a firearm, and that's another aspect of our law that we will talk about here in just a few minutes. We generally prohibit anyone from carrying or possessing a handgun on or in school property or during school-related functions. So where it comes to school grounds, unless you are, say, a student resource officer, having access to a firearm on school grounds, although there have been efforts to change that to allow teachers to carry on school grounds, but the general public would still not be able to. And we also provide that a parent or guardian of a child who intentionally allows that child to possess a firearm, there is actually a criminal charge for that, for endangering that child, and therefore also creating a public endangerment. But other than that, that's really where the bulk of the protection lay in terms of our legal system. Now, I want to make a quick language note before I move into actually talking about the laws. The next several slides use language directly pulled from the Indiana Criminal Code. That language, the language in general of the criminal justice system and or law enforcement, is not always fully trauma-informed, fully person-first, which is the approach that we typically take, the advocacy community typically take when we are talking about individuals who have committed acts of harm, who have engaged in criminal activity. We try to still use very person-first language. Somebody is not defined by the worst things that they do. But the language that is used, because we're discussing the criminal code, not as trauma-informed as I might like it as an advocate. So I always just try to make that note before I go through any of the statutes. So IC 3547-2-1, and that's the Indiana code. If you go to the Indiana code website, you enter in those numbers. This will bring up this criminal citation. And I'm going to go through these kind of in order because they build on each other. 47-1 is possession of a handgun by a domestic batterer. So this is the law that kind of covers the gap before serious violent felon. And it says, unless a person's right to possess a firearm has been restored, and it gives you the citation under which you can actually apply to regain your access to a firearm, a person who has been convicted of domestic battery under the criminal statute may not possess or carry a handgun. And I'm pointing out specifically this addresses a handgun. It's not firearms in general, but we will get to that in just a second. It's a Class A misdemeanor. So it is the, it is the higher of the levels of misdemeanors. It's a serious crime. But it's not, it's typically one of those that's kind of an added charge. It's not going to be something that there's a lot of accountability for. It's going to be something that's added on. And kind of as a standard practice for a lot of prosecutors and a lot of prosecutors' offices, they will add this on as an additional charge, which ends up being a bargaining chip. It's something that they can drop if somebody is willing to plea bargain to another charge. Or it's something that somebody can plead to in exchange for dropping what might be a more serious charge that carries a higher level of accountability, but they're still being convicted of a crime. And so this is one of those that's kind of a pro and a con, because it does give the ability for some accountability. It does carry an additional level of responsibility. It's holding somebody accountable for the act of, having a handgun when you're a proven danger to others. But it's not that, it's not that level of serious. It can be elevated to a level 6 felony, which is the lowest level felony, if there's a prior conviction. So if you've done it before, you got convicted, you do it again, they're going to take a little bit of a harsher line, which that level of elevation can be a deterrent, but it is, kind of that lowest level that we add in there. 4-3, so the next kind of section within that citation, is pointing a firearm. It's a level 6 felony, starts out at a felony level charge. It's a Class A misdemeanor if the gun is unloaded. Which I always love that they kind of differentiate that. I think it goes to intent, because if it's unloaded, you know you're waving a firearm, you're using the power and control that comes with the presence of a firearm. If it's unloaded, it can demonstrate at least a lack of intent to actually cause physical harm. The law does, however, assume that the gun is loaded. I think that's a good way to go. If somebody has a gun in my face, I'm not going to stop and ask if it's loaded. And unless it's a 6-shooter, I can't tell. So I think that's kind of the one benefit that they do have, is if that gun is present and pointed at somebody, then that is a crime. I'm showing an intent to at least use the fear that can be induced by that firearm. It's having the gun be unloaded is not a defense. It's not saying, well, I didn't, mean to do harm, therefore I cannot be, held responsible for my actions. But it is, again, a mitigating factor where they can say, well, at least it wasn't loaded. Moving kind of up the ladder, this is the serious violent felony statute, unlawful possession of a firearm by a serious violent felon. And notice again the term firearm versus handgun. So under the statute IC 3547 4-5, it is a level 4 felony if somebody who is convicted of a list of charges, and the list of charges actually just got expanded in 2022's legislative session to include strangulation, to include attempted murder, which seems like it's an odd one that wasn't on there, to include some other charges. I think all told, there's about 14 charges, all dealing with violent crimes. Domestic battery as a felony level charge is on there. Only at a level 5, though. So if you are convicted of the least serious felony level domestic battery, it still does not get you on, it still does not qualify you for this loss of access. It has to be as a level 5 or below, which the way that they kind of assign seriousness to felony levels in the state of Indiana, it's actually a descending order. So a level 6 felony is the lowest level seriousness. Level 1 is the most serious felonies. That's your murder charge, stuff like that. So this dictates that if you are convicted of any of this list of, I think now the crimes lie at 17 total, which include domestic battery, strangulation, attempted murder, those types of crimes, you cannot have access to a firearm. So any kind of firearm, not just a handgun. unlawful possession of a firearm by a domestic batterer. So there are ways that they kind of build in. And ostensibly what happens is they kind of realize how silly it is to leave off domestic battery from that list of charges. So they kind of add in a law to cover it. So this is 3547 4-6. It applies to all firearms, not just handguns. And I think that is a oversight that was very well corrected. One of the arguments that you can make is if you're using a long gun, if you're familiar with how to use a rifle, you probably have a much higher likelihood of being able to harm somebody from further away, not having to be up close and personal. So it certainly is a gap that needed to be closed. And the other thing to kind of point out here is that this uses our state definition of domestic battery. So the federal definition of what qualifies as a domestic violence crime and the state definition are different things because of what they say, what they call the qualifying relationship. Within the state of Indiana, we define domestic broadly. It includes dating relationships. It includes relationships where you may have a child in common. It includes individuals who are married or living together as if married. So it is a broader definition of the term domestic violence, or in terms of family or household member. So what it does is allow our state law to actually be more restrictive of who can have access to firearms when this statute is put in place. And so using the state definition is actually a benefit to us in terms of protecting survivors, because it closes what's called the boyfriend loophole, which that boyfriend loophole on the federal level basically says, unless you are living together, or unless you are married or living together as if married, it doesn't qualify as a domestic relationship. So all of those federal gun restrictions that restrict access to firearms on the federal level don't apply. So within the state, we actually went one step further, which is a benefit for us. And then unlawful possession of a firearm by a dangerous person. So it's not somebody who has been convicted necessarily. It is basically kind of under our red flag laws, the Jake Laird law. It is essentially saying we are recognizing that you pose a danger to yourself or others based on your behavior, and therefore you can no longer have access to firearms in this period of time. And ostensibly the judge will look at it and say, for X period of time, you have to surrender or relinquish your firearms until such time as you can be found to no longer be a danger to yourself or others. It's a Class A misdemeanor. And it includes what's referred to as the knowledge of criminal action, meaning that somebody has perhaps used that firearm or has access to that firearm with the intent to use it towards a criminal act. It's really kind of convoluted in how it's applied. It's not applied very often. It is really kind of it's the opportunity for law enforcement to try to protect the public from somebody who maybe has access to firearms, but there's no way to restrict them. They don't have a previous conviction. They aren't subject to a protective order. Maybe there's not a way, not a category under which they would qualify for a protective order where they could be that respondent. And therefore, it just gives law enforcement another tool to use to try to at least temporarily remove the threat of that firearm from the general public. And then unlawful transfer, this is related to that statute, basically saying that you cannot get rid of a firearm. You cannot, if you are not eligible to have a firearm, you cannot get rid of that firearm to keep yourself, to keep yourself safe from being charged with this crime. Ostensibly, it applies to those people who are under those red flag laws. You pose a danger to yourself or others. You haven't committed a crime with that firearm, but the threat is there. And so again, element of the knowledge of wrongdoing of the crime. I know it's wrong to give this person my gun. I shouldn't do it. I did it anyway, and therefore I need to be held accountable for it. Those are really like that progression can be kind of convoluted. So I want to double check and make sure, are there any areas where that's unclear, or is especially in terms of the applicability, when it applies, when which law applies?
Do you feel like between this and the previous law that you were talking about, that there is like, which is the most common effective tool that you see survivors being able to use to get legal remedies?
We're actually going to get to that because I haven't talked about it yet. So what I want to talk about is first the mandate to prevent further violence, because this is a tool that should be used way more than it is. But the short answer to your question, Julie, is the best tool that can best be employed, particularly by survivors, is going to be our Civil Protection Order statute, which I'm going to talk about in about 3 slides. But this is another one that really should be utilized much more often than it is. And it really isn't. And this is one of those that I wish, and particularly law enforcement, a lot of them just aren't aware that they can do it. And a lot of them, there's a sense of liability. Well, I don't have the right to take somebody's guns away just because. And they actually do. And then it's just a matter of kind of making sure that they take the right steps to justify it. So this is what we call the mandate to prevent further violence. This is IC 3533 1-1.5. And basically what this means is this gives law enforcement the authority, and it's some pretty broad authority, when they respond to the scene, particularly of a domestic violence incident. This specifically addresses what they can do on the scene of a domestic violence response. And they are empowered. They are, by this law, empowered to confiscate firearms, ammunition, and other deadly weapons. That's, I think, also something that's overlooked sometimes, is other deadly weapons, which is a broad term. It doesn't specifically just say handguns, rifles. It can apply to all kinds of things. If somebody has in their garage, that's a deadly weapon. If somebody has a baseball bat collection, that's a deadly weapon. And if they have demonstrated, which is what the law says, they've demonstrated that they will use that weapon against that survivor, then law enforcement has the right to confiscate it preemptively, to say, we believe that this item or this weapon posed a potential danger, a very real danger, and therefore temporarily we took it out of their possession, just to give them time for it to, and it really is kind of like the cooling off period law, right? So law enforcement can confiscate, remove that item from the scene, and there's 3 things that have to be true. So this is one of the things that can be confusing about this law, is all 3 of these things have to be true. They just have to be able to document it. So they have probable cause to believe that a crime involving domestic or family violence has occurred. They're showing up on the scene. They've been called because of a domestic violence incident. They walk in and they have probable cause to believe that this thing actually happened. Now, notice it doesn't say probable cause for an arrest. Probable cause to believe that this has happened. So just that probable cause is point 1. If it meets that requirement, point 1. 2, a reasonable belief that the firearm, ammunition, or weapon exposes the victim or survivor to an immediate risk of bodily injury, or was an instrumentality of the crime involving domestic or family violence. So to use my example about the baseball bat, if they show up and the house is absolutely trashed because that partner causing harm used the baseball bat to start swinging and breaking items and destroying things and putting holes in the wall as a form of intimidation against that survivor, it was instrumental to the commission of that crime. So it meets those requirements. And then 3, observed that firearm, ammunition, or deadly weapon at the scene. Did they look around and see the baseball bats hanging on the wall? Did they look around and see the gun stuffed under a couch cushion? They see it. they now have, if those three things are met, they have the ability to remove it temporarily. When they file the report, they filed a report that says, under the mandate to prevent further violence, here's the IC code. We removed these items. And then in the next kind of conversation is, until such time as, that person can come down to the police department and retrieve their items after a certain period of time. If charges are not filed, if, pending the further investigation, however that needs to be defined, and that can be very broad, but police are empowered to do that. They have the ability to do that as long as they document it in their report that they are following this, and all three of these aspects of this crime are met.
Caryn, so I want to ask
Excuse me.
follow up about that, because I think that that's really interesting, and I'm wondering, from your perspective, is that something that isn't typically happening because law enforcement isn't as familiar with that code? Is it not happening because there is kind of a feeling that might escalate abuse more, or is it simply like the scale, knowing that IMPD responded to 32,000 DV calls last year? Like, what's your sense of why this isn't the typical handling?
So my experience and my conversations with law enforcement, particularly when training law enforcement or having conversations around what are tools that can be utilized, is it's kind of a both and situation. Most officers do not know that this citation and that this tool exists. It's not well trained on. It's certainly not something. Now I can say that I know my friends who do law enforcement training. I know Dottie Davis, who does law enforcement training at the Law Enforcement Academy, who handles their domestic violence training. I know she talks about it, but she's talking about it during a 10-week period of time where she has, these folks for 4 hours. And this is one piece of information that they're getting during this avalanche of all of the training information they have. It's also not well supported within many departments. And by that, I just mean they're looking for, and they are training on and reinforcing, looking for probable cause to effect arrest, looking for, here are the domestic violence laws that exist, here's how you intervene. It's one that kind of falls by the wayside because it's so often not used. The other issue that you have is you have a lot of individual officers who will look at that and kind of through the lens of, I don't have the right to take somebody's guns away unless. They don't feel like just the presence of that gun or the presence of that weapon and then the use of it to intimidate. Now, if it's used to harm somebody, if it's a shooting, they recognize that they have the right to take that gun into continuity. But there is an overall approach and feeling of, unless it's used to actually commit an act of harm, I don't have the right to take it preemptively. And that clearly, as the statute states, you are empowered to do this to prevent violence. You can do this to keep that from happening. They're not keeping it. They're not taking it and saying you can never have your firearm back. We're taking it to remove it from the situation where, but for, that gun being there should we have to leave, or being there after things escalate again, that's more likely, that the primary reason why the presence of a gun causes such an increase in harm is because guns cause a lot of damage in a single instant, and you can't take that back. And so the presence of that gun not being there, the lack of presence of that gun, can be the difference between life and death, or can be the difference between serious injury and no injury. And so, but again, it's not looked at as something they can do preemptively or proactively. So I think that's one of the big hurdles that we continually try to get over. And storage is also an issue. One of the things law enforcement often says when we talk about firearm surrender, which we'll talk about in just a second, is where are we going to keep them? it is an issue. Is it an issue that we could probably figure out if we sit down and talk about? Yeah, but it is an issue. So I understand that. So I want to talk very quickly. This is another law that is similar to, it's one that often should be used or can be used where maybe it's not a domestic, maybe it is another type of incident, but it's one that it's another similar type law to that mandate to prevent further violence. And most of us, particularly from the Indianapolis area, understand the reference to Jake Laird, the Jake Laird law. And it specifically addresses confiscation and confiscation of firearms from individuals who are identified as a risk to themselves or others. Ostensibly, it says if you have reason to believe that this person is in a state of enhanced risk to others and they have access to a firearm and you see that firearm, you know that firearm is there, law enforcement can remove the firearm first and then go to the court. Then it's up to the prosecutor to file the additional paperwork and documentation with the court to have that the court order that says they cannot have access to the firearm under that law, under 47-14-1, because they pose a danger. Basically, they have to establish, when they do that, they have to establish through clear and convincing evidence that the person is dangerous, and why they pose a danger to themselves or others. Then, what makes the difference in this law is that it actually spells out a procedure by which that person who is determined to be dangerous can then reestablish their right to have access to a firearm. When that person seeks return of their firearms, they have to prove that they are not dangerous as defined by the statute. They no longer pose a risk to themselves or others if they have access to a firearm. And so it gives the entire kind of arc of the process. Yes, we recognize taking a firearm away from somebody who is dangerous proactively can be protective. We also recognize we have to give that person the opportunity to make the argument they are no longer dangerous and deserve to have access to their weapon. And that brings me to then what I mentioned earlier, Julie, kind of one of those best tools that survivors have access to protect themselves from the presence of a firearm or use of a firearm, and that's our civil protection statute. Our civil protective order statute is written in a way that specifically states that somebody who is a respondent in that protective order, so the partner who's causing harm, should not have access to firearms. And if we know they have access, then proactively, to keep somebody safe, we should remove that access. So the court may, and we highlight that because it has to be dictated by the court, that the court remove their ability to have a weapon. The court specifically order that. After notice and a hearing, prohibit a respondent from using or possessing a firearm, ammunition, or deadly weapon, and direct the respondent to surrender to law enforcement the firearm, ammunition, or deadly weapon. Now, we regularly see the use of, and I'll say regularly, it's probably not as often as it needs to be. If we look at some of the statistics, we know that in protective order cases, only in about, I think the last statistic that I looked at, only in about 30% of some of those cases do they even request that firearms be, that they be Brady disqualified, that they not be allowed to possess those firearms. And it's ordered in even in a lower number than that. But it's also a matter of having something put in place on the backside. And I'm going to talk about that in just a second. But the statute itself, our Civil Protective Order statute, the language applies to any protective order under our Civil Protection Order Act. So if you are a survivor or victim of an act of domestic or family violence, stalking, sexual assault, or harassment, that kind of additional area of harassment order that was put in place a couple of years ago, 2 or 3 years ago, that also disqualifies the respondent from owning or possessing a firearm if they meet those requirements. There is now this additional kind of category of protective order that you can get that is for grooming, particularly for individuals who where the protected party is a minor. It's up for debate whether or not those folks can be qualified under the other factors that have to be present, that they do not have access to their firearm. And so it's a little convoluted and it's really hard to dig into. Overall, the conversations that myself, Carrie, our legal counsel, other attorneys that I've worked with say not so much. So it's pretty much, if you're looking at the protective order statute and saying, I need a protective order, this person has a firearm, the likelihood is they're going to fall within those other categories anyway. It's broader than the federal law because, again, it's not limited to intimate partners and it includes deadly weapons. So that boyfriend loophole that I mentioned earlier. And it does, there's some kind of paperwork pieces that you have to, administrative pieces you have to make sure get done. The judge basically has to check a box and make sure that they specifically indicate that as an additional requirement of the protective order, this person cannot have their firearms or cannot have any firearms. So they have to make sure that the judge specifically orders that and indicates that on the protective order. As long as that's done, then hopefully that means I's dotted and T's crossed, right? There is also within federal law, 18 U.S.C. 925, the official use exception. And what that means is that weapons that are issued by the state or federal government for official use by law enforcement officers, military, other individuals who are deputized to carry a firearm because of official duties. But it only applies to that official duty weapon. So if they have, I've got my official duty weapon, and then I also have my own personal, collection of firearms, they can be ordered to surrender those personal firearms, but their official duty weapon is off limits. They have to be able to have access to that. And that only applies in civil protective orders, not under criminal no contact orders. It's a whole different situation. So what that brings us to is that question about what can we do? What are the tools that we have to be able to use? And that is a surrender protocol. As I mentioned, we have this law that says on the front end, no, you can't have the firearm. We have to make sure that that's utilized. However, one of the biggest issues that we end up having is that it's done on the honor system. So you're the respondent of protective order, you get a protective order document that says, hey, here are all the things you can't do. And one of them is you're not allowed to have access to firearms or ammunition. Well, okay, what do I do with them? There's no direction that says, here's what you do if you have firearms or ammunition, which we believe you do. And so one of the things that really needs to become standard practice, and we do have some jurisdictions where that is practice. We have some courts within counties where they have their own practice, but this is not widespread. We typically rely on what we call the honor system. We tell that respondent, you're not allowed to have a firearm, you're not allowed to have ammunition, get rid of it. And then there's no check-in also that says, did you get rid of your firearm? What did you do with it? Did you get rid of it in a meaningful way? Or did you give it to Uncle Bob, who anytime you go out to Uncle Bob's house, you say, hey, Uncle Bob, give me my gun back. And Uncle Bob gives you the gun. So did you get rid of it in a meaningful way? Is there any accountability to that? And that's one of the areas where we have a lot of room for improvement and enforcement that will make a very quick difference. And it's a real simple process, identifying those prohibited individuals, which you do through the protective order. If you're the respondent in the protective order, you meet these 3 qualifications, you're not allowed to have firearms or ammunition. So, okay, do you have access as a prohibited individual to a firearm? Do you have your guns? One of the things that we talk about is working with survivors to identify. Does this person have guns? What kind of guns do they have? Especially if they're living in the house, they are likely to know at least most of, if not all of those guns. They're likely to understand or be able to say, oh yeah, they've got 3 handguns and 2 long guns. They've got, 2 handguns and 2 hunting rifles, whatever it is. So having a conversation with survivors when we are enacting this process to say, the guns that you've seen, the guns that pose a threat to you, what are they? Where are they? How do we know that they exist? Can you give us documentation of that? Specifically ordering the firearms surrendered, and here's how to do that. So not just saying you can't have them, But let's also then say, hey, here's how you not have them in a safe way. And then ensure compliance. So here's how you not have them in a safe way. You turn them over to, this location between these hours on these days. They give you a receipt, documentation that you've turned them in, and you bring that receipt back and submit it to the court. So we ensure compliance that way. That is safer all around. It's not only safer for survivor, it's also safe for law enforcement, because law enforcement can then confirm that if there's an incident they are walking into, there are no guns in this house, they've been turned over, or they know they haven't been turned over. We're also not asking law enforcement to go out to somebody's house and say, you're not allowed to have guns, give us your guns. So it's safer all around, because you're also talking about that partner who causes harm has a process by which they can surrender them safely. They're not just, driving down to the police department with their bag of guns going, who do I give these to? Which is a recipe for disaster. And then the last piece that I want to mention, we've talked a lot about laws that say you, as a person who pose a danger because you are convicted of a crime of domestic violence, or in this case, because you are subject to a civil protective order. We're talking about state and federal laws that say that. There is a case getting ready to go before the Supreme Court. It's actually scheduled for oral argument on November 7th. So next Tuesday? Is that Tuesday? I think so. Next Thursday? Next Tuesday. Sorry, double checking the date. There is a case that goes before the Supreme Court. It is the Rahimi case, the United States v. Rahimi case out of the Fifth Circuit. It specifically challenges the federal law and therefore the state law that says if you are the respondent in a protective order, you are documented as a person of risk and should not have access to a firearm. It basically says those laws are unconstitutional. And SCOTUS is hearing this case next week. In the period of run up to that, one of the things that happens as the cases go to prepare for argument is that organizations, individuals with specific interest will submit what are called amicus briefs, or friends of the court briefs, basically saying why, as a practitioner in this area or an individual or organization of expertise in this area, here's why this law is important. Here's why it should stand. Here's why it is a good thing for the public, in this case, the public safety. There were 48 friend of the court briefs filed on behalf of maintaining that legal protection. Everybody from prosecutors groups, law enforcement groups, public health researchers, emergency room physicians, the American Medical Association. It ran the gamut of who submitted friend of the court briefs. And I can share the link to where you can find all of these briefs. But ICADV's legal counsel, Carrie Hyatt Bennett, co-authored with the legal counsel and some other representatives of the 54 state coalitions that do the same thing that ICADV does. They wrote a brief, submitted a brief as a part of these 48, specifically addressing the work that domestic violence organizations, domestic violence coalitions, the violence that we see. And we actually solicited stories from survivors who said, but for the fact that my partner's gun was taken away because of the protective order, I am absolutely positive I would be dead. I would be that outlier. Wow. I link to in the materials that our brief is linked. I can send it to you if you want. But this is one that we are keeping a very close eye on, because basically everything that I just talked about is hinging on the outcome of this case at this point. Wow. Because once you talk about whether or not you can have a gun as a respondent in a civil protective order case, it then opens up all of those other restrictions as a convicted domestic violence offender and so on. So we're keeping a very close eye on that.
Wow, I think that we've got about 5 minutes left. So one thing that I want to really kind of like reflect back is my takeaway is that domestic violence is so personal and is so individual to survivors and the households that this is kind of like activating it. And yet these laws that affect everyone as a collective are confusing, nuanced, and
Mhm.
I feel particularly grateful to have such a strong advocacy in ICADV to be lobbying and really voicing um, on behalf of survivors and on behalf of communities. So do we have any questions? I don't see any in the chat, but just want to do a shout out to see if we have any questions as we have a couple more minutes.
And I'm going to put that up there for the last T.
Yeah, in the slides there, I think is a link to Yamika's brief.
There is, and I actually can pop it up real quick in the chat because I happen to have it. I was actually looking something up in it. Hopefully this works because it's got the extension in there. But what I can also do is I will also put the link in to SCOTA. It's all on the Supreme Court blog. You can pull up all of the briefs, and the brief that Carrie co-wrote is the brief on behalf of DC Coalition Against Domestic Violence et al. So all of the coalitions got together under the kind of moniker of the DC Coalition to submit them all. Yeah, that is the one that she helped write. She's also getting ready to write some other pieces, so you might check our blog as well because I know they're linked there.
Yeah.
She's been amazingly active and very helpful through this entire process. I mean, trying to unravel everything that goes on at the Supreme Court level is kind of unknowable. I mean, it's unknowable magic. So it's very interesting. But that links all of the briefs. So there's why, educators and practitioners, New York County Lawyers Association, all of them are amazing reading.
This, I think, was so informative. I would love for us to do a part 2 that's like from the perspective of either an individual experiencing domestic violence or someone who is very close to someone in terms of like, what does it look like to enact, like how does one go through that? But I think like having this zoomed out perspective is just, it's so complicated and overwhelming. And also, I really think that it highlights the important work that you all are doing. So I want to be respectful of everybody's time as we wrap up. You saw in the chat, if you're interested in learning more about the work we do at Coburn Place, we have an open house on Tuesday, November 7th, and there is a link in the chat to that. And yes, there also is a link to Caryn's slides, and we'll send those out afterwards as well. Thank you all so much for coming. Caryn, thank you so much. You are brilliant.
Thank you, everybody. Have a wonderful day and have a safe Halloween for those who are celebrating or doing fun things today. And stay warm.
Thank you all. Have a great rest of your afternoon.